Okay, that was 7 minutes and something, and we're now rolling for the third one.
The following presentation is brought to you by ATG Trust. I'm Scott Drake on the Legal Broadcast Network, and a recent article in Tax Notes, tax lawyer Rob Wood examines the fundamental concept of constructive receipt and its impact across a variety of tax fields. He is partner at Wood & Porter in San Francisco and host of the Tax Law Channel here on the Legal Broadcast Network. Welcome back, Rob.
Thanks, nice to be here.
Constructive receipt, the concept of money that's coming to you that you haven't actually collected yet, but you still might be liable for taxes, right?
That's right, and this, I have to say, is something that I think most people and most business people feel they have a good handle on. I think there is these days a fairly high degree of sensitivity to it, but I must say a lot of confusion, even confusion among tax people, but certainly among non-tax people. So I guess we should start with the very basics. As you say, sometimes you're taxed on something even though you don't have it. And first I think we should start with the sort of class of people this applies to, and that would be cash basis taxpayers. So if you are, and that's certainly almost all, virtually all individuals. It's many small businesses too. If you are a big company, then you are almost by definition an accrual basis taxpayer, which means that you accrue income and expense when you are entitled to the money, not when you receive it, and when you are required to pay, not when you pay. So if you think about it, the constructive receipt doctrine is for cash basis taxpayers like you and me, Scott, but accrual basis people don't have to worry about constructive receipt because it's sort of already built into the accrual method of accounting.
You think about it in the context of cases resolving litigation. We have lots of settlement people here on the Legal Broadcast Network, and that's a concept that they have to deal with every day.
It is, and that's a good segue because you're right. I mean, the focus of lawyers and certainly many listeners on the Legal Broadcast Network is litigation settlements. And at what point do you have constructive receipt of the money? Is it, for example, constructive receipt if you're sitting in a settlement conference late at night or a mediation meeting, and everybody shakes hands saying that plaintiff and defendant agree the case is settling for $1 million, and that they're going to draw up a settlement agreement? I mean, does that mean you have receipt of the money? If you the next day decide you want to try to structure, is it too late to do that? The answer, by the way, on the latter question is no, it's not too late. On the former question, is it constructive receipt? No, clearly not. And why is that? Well, there may be, in some general sense, entitlement to the money, but there is a legal release that has to be prepared. It has to be signed. And until it's signed, the money isn't payable to the plaintiff. So both the plaintiff and the plaintiff's lawyer don't have either constructive or actual receipt at that point.
Talk about constructive receipt applications with escrow and qualified settlement.
Yeah, well, this is where it gets touchy because, and I do, as you say in the article, I do talk about some of the authority there. In the case of well, first of all, before we get to that escrow, let's talk about what may seem, I don't even know if escrow is the right term, what may seem the most sort of innocuous of all accounts, and that is the good old-fashioned lawyer-client trust account. So if a case, let's go back to my hypothetical and say the parties agree late at night on the $1 million settlement, defendant's going to pay $1 million, plaintiff's going to receive it. Let's say the lawyer, plaintiff's counsel is getting 40% or $400,000. So $600 is the number that's going to the plaintiff. Let's say the settlement agreement is written up, it's signed, the money hasn't been paid, and then the money, maybe the plaintiff and defendant are still talking about exactly how it's going to be paid, which, by the way, in my view is a mistake. If the settlement agreement's signed, the defendant can simply pay the money over, and let's assume that's what happens. So the money lands in the lawyer's trust account. fundamentally, that is, of course, not just constructive receipt, it's actual receipt. The lawyer is the client's agent, so both the plaintiff's counsel and the plaintiff are treated as having receipt of that money when it hits the trust account. So, Scott, to go to your questions, is what if you have some kind of an escrow arrangement or a qualified settlement fund? Then certainly the entity has receipt, but depending on the facts, and I guess the qualified settlement fund would be the easiest case, because I think we know by instinct one of the reasons you do a qualified settlement fund is it prevents either constructive or actual receipt to the parties. So defendant gets credit for paying the money, can claim a deduction when it goes into the qualified settlement fund, but assuming it's been properly set up, neither the plaintiff nor plaintiff's counsel has constructive or actual receipt.
Talk about a situation where perhaps when a qualified settlement fund is in use, money is received by the attorney. Does the client or the plaintiff have the opportunity to say, hey, it's like the end of the year, can you just not give that to me until January?
Yeah, that's a tough one. I mean, this happens a lot in the real world. Technically, the answer to that is no. I mean, obviously the plaintiff can say that and the lawyer can do it. The question, of course, is does it work for tax purposes? The IRS would say no, and the IRS would mostly be right on this. I mean, there are some things one can do. I mean, I've seen it happen. I've sort of by necessity sometimes had to help people with this problem. But the law is pretty clear that, and by the way, speaking of qualified settlement funds, that sometimes is an answer. Sometimes there is a way to retroactively create a qualified settlement fund by what's called a relation back election. But sort of beyond the esoterica, the basic answer is anytime that you have someone saying, oh, please don't pay me next year, sort of alarm bells should be going off and you should be thinking constructive receipt, because that's classically the kind of law that gets applied when someone is asking for a delay in payment.
Safe to say things like qualified settlement funds are a good solution, but probably more important is careful planning and documentation, which I think.
Yeah, that's right. I mean, sometimes I think people, and I try to address, at least briefly in the article, the topic of sort of partial disagreements. So you may have, let's say, even after signed settlement documents are done, and there's no question but what the defendant owes, let's use the same number, $1 million to the plaintiff. You know, maybe the money's about to be paid, or maybe it's even paid, but a dispute erupts over how the money was to be paid out, or I guess it's hard to imagine in a well-drafted settlement agreement, but maybe there's a dispute about the amount. Maybe it's there are some offsets or something that are to be considered, and they're not crystal clear in the document. If it's really clear that, say, $600,000, let's say, out of the $1 million is payable, and that can be dispersed from the escrow or the lawyer's trust account or something, but there's a fight about the other $400,000. Sometimes there are good arguments for splitting the baby, so to speak, and only having income on the uncontroverted portion of the payment and not on the rest. So sometimes, as you say, Scott, documentation is key. Sometimes it's a matter of trying to record and make a good record of what happened when, so that you don't sort of have the record reflect that you actually had the right to income before you really had the right to it.
Thanks, Rob. It's been a pleasure. We appreciate you joining us.
Thank you, Scott.
Rob Wood is partner at Wood Porter in San Francisco. You can find this article and more at woodporter.com, also on the Tax Law channel, where he is host here on the Legal Broadcast Network. This presentation was brought to you by ATG Trust. Thank you for watching. I'm Scott Gregg on the Legal Broadcast Network.